Every person who lawfully carries a firearm needs to understand this, because it is one of the most common and most dangerous mistakes made after a legitimate act of self-defense. After years of handling self-defense firearm cases, speaking with those involved, and watching how these situations unfold for families long after the incident itself, a clear pattern emerges. People are consistently misinformed, not by the law, but by television, movies, and media portrayals of how police encounters actually work. This misunderstanding can destroy an otherwise lawful self-defense claim. It is not optional knowledge. It is survival, first physical, then legal. Nearly everyone has seen the scene. The suspect is arrested and brought into a dimly lit interrogation room. A detective leans over the table, sleeves rolled up, tie loose, a single light hanging overhead. Tension fills the room. Then, at the perfect dramatic moment, an attorney bursts in, shuts everything down, makes a clever remark, and rescues the client from disaster. That scene makes excellent television. It also bears no resemblance to reality. If you rely on that fantasy, you will suffer real consequences. In the real world, if the worst night of your life happens, no attorney is bursting through a door to save you. No lawyer can interrupt an interrogation, shut off a recording device, or order detectives around, attempting that would result in immediate removal and arrest. The system does not work that way, and believing it does is a serious and dangerous error. If you ever find yourself in this situation, you must understand a hard truth. The only person who can protect your legal rights at that moment is you. You already survived the violent encounter itself. Now you must survive the legal one. The law is not gentle. It is enforced through power, authority, and consequences. Ignore lawful commands, court orders, or police procedure, and the response will be immediate and forceful. That is not criticism of the system. It is reality. The failure here is not with law enforcement or the courts. The failure is assuming fictional portrayals are accurate. That assumption costs people their freedom. You deserve better preparation than that. The most important concept to understand is the difference between invoking your right to remain silent and invoking your right to an attorney. These two rights are not equal in practice. One is significantly stronger than the other. Invoking your right to an attorney is the single most effective legal protection available to you after a self-defense incident. When you clearly, politely, and firmly state that you will not answer questions until you have spoken with an attorney, the rules change. Law enforcement should stop questioning you. That does not mean they will stop observing you, documenting your behavior, or building a case. It means you have activated a legal safeguard that cannot be invoked by anyone else on your behalf. Police officers are trained to gather statements. That is their job. If they believe you acted lawfully, many of them will internally wish you would stop talking while simultaneously continuing to ask questions. That is not misconduct. That is procedure. You must not mistake professionalism for protection. Consider how officer-involved shootings are handled. Officers are not required to give immediate statements. They are given time. They sleep. They consult attorneys. They stabilize emotionally and physically before giving what may be the most important statement of their careers. Civilians deserve no less protection. The stakes are identical. Freedom versus incarceration. Family versus prison. No attorney can invoke your rights for you. No prior paperwork, affidavit, membership card, or emergency phone call changes that. Rights must be asserted verbally by you in the moment. If you are a competent adult, the responsibility is entirely yours. Just as no one else can pull the trigger to save your life, no one else can invoke your rights to save your future. Invoking the right to silence alone is weaker. Police may continue attempting to question you. However, invoking the right to counsel creates a clearer legal barrier. Once invoked, questioning should cease. But understand this clearly. If you begin speaking again, you may waive that protection. Casual conversation, emotional explanations, or attempts to clear things up can undo everything. There is no partial protection. You cannot invoke rights and then talk your way around them. Many people believe they have nothing to hide because they did nothing wrong. That belief is naive. Trauma affects memory. Stress distorts perception. Exhaustion, adrenaline, fear, and low blood sugar all impair recall. People make mistakes not because they are dishonest, but because they are human. These mistakes are later framed as inconsistencies, lies, or evidence of guilt. Even well-trained, responsible individuals routinely get basic facts wrong immediately after a defensive incident. Times, distances, directions, number of shots fired, sequence of events. All of these details are commonly misremembered. Once stated, they become permanent. They will be compared against physical evidence, surveillance footage, and witness statements. Discrepancies invite suspicion. Statistically, most defensive firearm incidents do not involve shots fired. In the majority of cases, displaying a firearm ends the threat. That is a good outcome. Carrying a firearm is about preserving life, not taking it. When shots are fired, the scrutiny increases exponentially. If the attacker flees and no one is injured, you are primarily a witness. In that situation, focus on describing the suspect and the direction of flight. Avoid unnecessary specifics. Do not speculate. Guessing helps no one. Even small errors, such as misidentifying a vehicle's color in low light, can create credibility problems later. If shots were fired and someone is injured or killed, the situation changes entirely. The attacker or their associates may claim you were the aggressor. This happens routinely. Statements are made. Stories are coordinated. Without video or independent witnesses, the narrative becomes contested. In those moments, less is more. A brief statement acknowledging that you were attacked, feared for your life, and will provide a full statement after consulting an attorney is sufficient. Point out any weapons used against you. Do not embellish. Do not reconstruct the event on the spot. That is not the time. Finally, understand this. Anyone in your immediate circle becomes a witness. Spouses, friends, children, roommates. Anyone you speak to may later be questioned. Many cases are damaged not by the person who acted in self-defense, but by well-meaning loved ones who speak freely without understanding the stakes. They must be educated as well. Silence and counsel protect everyone involved. Law enforcement will almost certainly attempt to speak with the people closest to you. They will do so politely, professionally, and persistently. Friends and family often believe they are helping by explaining what you are really like, or by repeating what you said in moments of stress. From a legal standpoint, those statements can be devastating. Innocent inconsistencies, emotional interpretations, or secondhand descriptions can become exhibits in a criminal case. Anyone who spends time with you, lives with you, or was present before or after the incident should understand this reality. They are not spectators. They are witnesses. Education cannot stop with the person carrying the firearm. Everyone in that immediate circle needs to understand the importance of limiting statements and deferring to counsel. Law enforcement is allowed to speak with them, and they are allowed to speak back. That choice has consequences. Preparing your household and close contacts is part of responsible carry, whether people want to acknowledge it or not. It is also critical to understand that raising your rights is not an act of hostility or disrespect. It is a constitutional safeguard. Doing so politely and firmly is both lawful and prudent. Statements such as, "I am invoking my right to an attorney and will not answer questions until my lawyer is present," are clear, respectful, and effective. Anything beyond that increases risk. Many people struggle emotionally with this concept. They want to explain. They want to justify. They want to make sure the officers understand that they are the good person in the situation. That instinct is understandable and dangerous. The roadside, the scene of the incident, or the interrogation room is not the place to tell your story. That comes later, with counsel, when your mind and body have stabilized and when the legal framework can be applied correctly. The justice system is not designed to sort truth from chaos in the immediate aftermath of trauma. It relies on recorded statements, documented evidence, and formal procedures. When you speak too soon, you lock yourself into a version of events that may not reflect reality once the evidence is fully known. That mismatch is often used against you. This does not mean refusing to comply with lawful commands. Follow instructions. Be calm. Be respectful. Identify yourself as required by law. Secure your firearms safely when directed. None of this conflicts with invoking your rights. Cooperation with safety procedures is not the same as volunteering information. If there is a weapon used against you, whether conventional or improvised, make sure it is identified. A screwdriver, a baseball bat, a tire iron, or a blunt object may not immediately be perceived as a weapon by responding officers, especially in cluttered or chaotic environments. Briefly pointing out those facts helps preserve the scene and protects your claim. This is not storytelling. It is scene safety and evidence awareness. Beyond that, restraint is your ally. Silence is not an admission of guilt. Requesting counsel is not an admission of wrongdoing. These are the same protections afforded to law enforcement officers, public officials, and anyone else who understands the system. Expecting civilians to do less is unreasonable. The legal aftermath of a defensive shooting is not measured in hours or days. It can stretch into months or years. Decisions made in the first few minutes echo throughout that entire process. Many people who were legally justified in using force still suffer severe consequences because of what they said afterward, not because of what they did during the incident itself. Carrying a firearm carries responsibility beyond marksmanship and tactics. Legal literacy is not optional. Emotional discipline is not optional. Preparation must include the aftermath, not just the encounter. Anyone who ignores that reality is gambling with their future. Those who take the time to learn these principles are not paranoid. They are prudent. They are acknowledging that the legal system is complex, powerful, and unforgiving of mistakes made under stress. Hope is not a strategy. Preparation is. If this information feels uncomfortable, that is intentional. Comfort comes from fantasy. Safety comes from realism. The goal is not to encourage fear, but to replace ignorance with competence. Knowledge reduces risk. Discipline preserves freedom. At the end of the day, self-defense is about protecting life, yours and the lives of those you care about. That responsibility does not end when the threat stops. It continues through every interaction that follows. Understanding that distinction is what separates those who survive the incident from those who survive the consequences. The truth is often unpopular. It challenges assumptions and disrupts comforting narratives. But it is better to confront it now than to learn it the hard way later. Preparation is respect for yourself, for the law, and for the seriousness of the responsibility you carry. That is the reality of lawful self-defense in the modern world.